Yeah, sure.
Really, really bad.
Do you want to go back to your room and zoom in instead? Because if we close the windows, we're all gonna sweat to death.
No, because I have another class there, so it's like no point in going back.
Right. Well, the mask might actually help because it'll keep some of the allergens out. It'll sort of filter it.
Oh, I was only asking because in the class I just got out of,
Uh-huh.
like, I spent like the first 10 minutes doing nothing but rubber.
Oh, no. Yeah, I would normally just close them, but I think, like I said, we're all gonna just drip sweat if we do that. So if it gets too bad, let me know and we can maybe close the ones closest to you.
If it gets too bad, I might just like.
Yeah, that's fine. No judgment. I understand. Yeah, and I fully recognize that I actually used to be allergic to like everything outside, and then I did 5 years of allergy shots, and I'm only allergic to everything inside, so you know. It's and that's why the lights are off to try to keep it cool in here. But if anybody gets too sleepy, feel free to either just let me know or go turn the lights on yourself. Like that's fine. All right, so just updates. I realized I don't think I scheduled enough time for the jurors section. So we'll probably end up bleeding into another day, but that's okay, because then we can just move everything else down. So I'll keep you updated at the start of each class. We're gonna get back to actually like doing assignments and watching videos. Like I said, the middle of this class is like mostly me talking, and I think in the future, maybe I need to like move around some of the chapters to like jazz it up a little. So thank you all for hanging in there with me while I was just boring myself and you some days. So, today, what we're gonna do is start talking about jury selection. And there's an assignment for this that depending on how far we get, we'll either do today or we'll do at the start of class next Tuesday. And then, what we're gonna do next week, depending on like when we get through everything else, we'll probably start it on Tuesday. Is we're gonna watch the movie 12 Angry Men, which is about jury deliberations. So it's a nice representation of some of what can happen and some of the personal biases that jurors can bring in to the jury room. Alrighty, I'm taking attendance while I do this, and I'm just gonna scroll down to see who else signed on. Yeah, this is definitely the time of the semester where we will be missing some folks because they go to the beach. I mean, I can only judge so much on that. I did not have that as an option when I was an undergrad. If I had, there's no saying I wouldn't have also skipped class to do that. So, alrighty. So we talked just like in passing on Tuesday about juries in general and how you get selected for one. And so it's typically registered voters that are the selection pool, although some places use people with driver's licenses. And then the idea is there is random selection from the pool of all registered voters. That probably at this point they use computer programs that randomly pull people out. And then those people are called for jury duty. And a lot of, well, it's interesting. It varies drastically place to place. Here, I think in both Virginia Beach and Norfolk, you're called for a whole week. And you're kind of on standby. They let you know every night whether you're going to come in or not. Where I grew up in the Detroit area, it was with 1 day, but you had to go down to the courthouse. So it varies from jurisdiction to jurisdiction. So as I said, who can be a juror? Like I said, we'll come back to the assignment and do it all at the end when hopefully more people will trickle in. If not, y'all will get the points. But yeah, so the pool is from the voter registration. So then okay, you've got all these people, you've called them into the courthouse. They're sitting around in the waiting room, what happens? Well, then there's like another random selection, and a group larger than you need for the jury is pulled in. And then we engage in this process of voir dire, or to tell the truth, to select who will actually serve on the jury during the trial. So in theory, jury selection must neither systematically eliminate nor underrepresent any subgroups of the population. To encourage representativeness, that's a tongue twister, that's early in the morning. US Supreme Court cases like Stouter v. West Virginia in 1880 have forbidden systemic or intentional exclusion of religious, racial, or other what they call cognizable groups from jury panels. And cognizable groups are those that, because of shared characteristics, might also hold unique perspectives on selected issues. So the reason they use that term is to try to sort of cover groups. They didn't have to name every minoritized group, basically. So we're trying not to exclude people who are from low socioeconomic status, people of LGBTQ plus status, things along those lines. Before this case in 1880, all of the panels, the veneers from which they selected the jurors, were middle-aged, well-educated Caucasian men. So not a lot of representation there, right? Congress and the Supreme Court both require that the jury pool be representative, and that it be a cross-section of the community. The resulting juries would be more heterogeneous, and heterogeneous juries are expected to be better fact finders and problem solvers. The idea is, by having a diverse group of people, you're much less likely to just sort of like go with the flow and agree with what everybody else is saying. Whether or not that's actually the case is obviously up for debate. And representativeness gives the appearance of fairness and legitimacy of a trial and of the resulting verdict. Again, whether or not it's actually fair may vary drastically from case to case. All right, so step one, and again, I'll make sure it's clear where psychologists get involved here, is again, those people who are on the voter registration list or on the list of licensed drivers. You draw a panel of prospective jurors, and that's called the veneer. The Jury Selection and Service Act of 1968 required that voter registration lists be used as the primary source for jury pool selection, but such lists risk underrepresenting certain segments of the community. So who could you think would be underrepresented by voter registration lists? So young people sort of y'all's age who might not have registered to vote yet, right? Sometimes older adults or people who move around a lot, like folks in the military, right? So you're missing big swaths of the population if you're using that. So to increase representativeness, states use other sources such as lists of licensed drivers. They even include lists of people receiving public assistance to make sure they're getting an economic spread, and even unemployment lists. So what will happen if we're only using voter registration lists is that we'll get an overrepresentation of like well-educated, well-off people, right? But if we're using lists of people receiving public assistance and on unemployment, then that can make it so historically underrepresented groups are overrepresented. They're getting a larger percentage of jury summons, and thus they're getting like more burden on them. So it's sort of like, how do we balance that out? We haven't found a super good way yet. Once a pool of potential jurors have been drawn, each individual in the pool receives a questionnaire to assess his or their qualifications and ability to serve. Some are excluded by the law. So really interestingly, in most places, people who are blind are excluded from serving on a jury because they want people to be able to see the evidence. Also, people who have very low IQs are excluded. From those who are eligible for jury service and who return the questionnaire, I mean, because that's part of what happens is like some people just won't fill it out. Sometimes it'll get lost in the mail, right? So they're only going to get a percentage of those back. And then they randomly select members of the veneer from the returned questionnaires, and those people are summoned to appear for jury service. Many qualified jurors ignore the jury duty summons, even though this violates the law. It's not something that's typically enforced, but in theory it could be. There's also exclusions or non-responses and exemptions that can distort the representativeness of the jury. So for example, the last time I got a jury summons was when I was, I think, like 2 months postpartum. I was on my maternity leave. I was primary childcare. And I believe there was something about like nursing your daughter. And so there was a line on the survey that was like, you can be excluded for that reason, basically. But then we're missing homes, right? We're missing these sections of the population. Until recently, some members or like members of some occupations were automatically exempted from jury service. So for example, New York used to exempt physicians, firefighters, veterinarians, phone operators, and embalmers. And it goes back to the importance of each of these roles in small towns. So most states have now eliminated all, or at least most of these exemptions. That does not mean that those people have an equally likely chance of being picked once they show up for jury service. So for example, police officers, lawyers are sometimes much less likely to be picked because they're overly knowledgeable. My understanding is social scientists are the same way. I know that we know theories of crime and things along those lines. And so a sociologist or psychologist might be less likely to be picked as well. Okay, so that's step one. We just send out the questionnaires, randomly select people from the questionnaires that are returned, and then we have this pool, the veneer. So once that veneer has been selected, a process known as voir dire is employed to question and select the eventual jurors. And voir dire, I think I've said before, means to tell or to speak the truth. And jurors are expected to be very truthful in any inquiries about opinions they have, biases they have, whether they know the person in the trial, things along those lines. I don't know if anyone in here ever watched the show 30 Rock, but there was a great bit where wherever Liz Lemon, who's Tina Fey's character, got called for jury duty, she'd dress up like Princess Leia, and they would like just think she was crazy and dismiss her. But then like joke was on her at the end of the show because she tried to do it again and they were like, should we just need people? We don't care. Okay, you're still in the pool. So, you know, some people will sort of try to not be truthful, but the ideal is that they're truthful. And the true purpose of voir dire is to try to get as objective a jury as possible. What you'll see as I describe this process is it sort of gets distorted as we go through. So in jury selection, attorneys are going to choose people based on their agendas. And they're going to look for jurors who are going to kind of vote for their side, either convict or acquit. Each side has an equal chance to choose jurors in favor of their opinions. And so the ideal is that that balances out. And attorneys also get the chance to kind of suck up to jurors. So as the attorneys are questioning the jurors, they get to start like putting on their razzle dazzle, right? This is not a very complex process. There are 3 sides, 2 lawyers and the judge. They do have conflicting goals, and the most limited form of voir dire involves a small number of questions asked by the judge in a yes or no format and features group rather than individual questioning. So in some jurisdictions, the voir dire would be the judge deciding. And so they're yes or no questions. And again, you're asking them as a group, so you're asking people to kind of like raise their hand or things like that. Unfortunately, this is going to offer little insight into jurors' beliefs and attitudes. And not surprisingly, some jurors will not disclose important information because of privacy concerns, embarrassment, a desire to provide socially desirable responses, or a failure to recognize their own biases. The judge, even if they're not the one asking the questions, is the one who decides how voir dire is going to proceed within their courtroom. The judge really has the ultimate power, just like in other court proceedings. You know, if an attorney raises an objection, the judge is the one who decides. In federal courts, there's a brief voir dire where the judge asks the questions. The judge is more active. There aren't questions on opinions or beliefs. Instead, in federal court, the judge just asks, like, do you know anyone who's involved in this case? Or what's your exposure been to media about this case? In other jurisdictions, you have what's called extended voir dire. And this is where both the judge and attorneys will ask open-ended questions that require elaboration and cover a wide range of topics. Jurors are questioned individually in this case as well. There are several advantages here, as you could imagine, to uncovering biases. So they encourage jurors to talk more about their feelings and experiences, and individual questioning can result in disclosures that jurors might not offer in that group setting. The typical voir dire procedures involve compromise between the limited and extended versions. Both the attorneys and the judge will pose questions to the group of prospective jurors, and then they ask brief follow-up questions of selected individuals. So again, the attorneys are typically the ones in this extended voir dire or the compromise voir dire who are asking questions. And attorneys in a given case are allowed to dismiss jurors, say, thank you for your time, we're not going to be using you on this case, via what are called challenges. And there are different categories of challenges, and depending again on the jurisdiction, attorneys will get a certain number of each kind. So challenges for cause would be there's a clear reason to dismiss this person. An example would be their attitude about the crime. So I think I told you all this story about my mom getting dismissed because they were like, this is a mugging case, can you be objective? And she was like, no, I was just mugged last week. And they were like, thank you for your time. And she was like, what? Like, but that's what they were trying to do, is like find out whether or not she could be objective. Again, if they know the person on the trial, their opinion about punishment. So if they are anti-death penalty in a death penalty stage, or they say like everybody should get the death penalty, even petty crime, we're probably going to say thank you for your shot, goodbye, right? So basically in these challenges for cause, the idea is that the individual is so biased that they could not render a fair verdict, or in some cases they're unwilling to actually follow the law. And these you get an unlimited number. There's no cap on the number of this person is just so biased, we need to get them out of here. And usually this is really obvious to the judge and the opposing attorney as well. Then there's peremptory challenges. And these are ones that don't allow for debate or argument, and you don't need a reason to dismiss this person. Basically, you think as the attorney, this person's going to favor the other side, so you get rid of them. So these are limited, the number of these you're allowed. The more serious the case, the more you're allowed of these peremptory challenges. And the defense gets more, which is interesting. So these have multiple purposes. Peremptory challenges allow attorneys to challenge potential jurors who they believe will not be sympathetic for whatever reason to their client. They allow those in a lawsuit to play a role in selecting the people who decide the outcome, and therefore people may be more satisfied with the verdict. And they allow the attorney to begin to indoctrinate prospective jurors and influence those who will ultimately make up the jury. So again, this is the attorney's first like dog and pony show. You start convincing people and being smarmy to people right off the bat. All right, there's also a type of challenge called a Bastin challenge. And this comes from Bastin v. Kentucky in 1986. When a defense attorney believes the prosecution's peremptory challenge was motivated by racial factors, then that attorney, the defense attorney would initiate the Bastin challenge. And the judge asks the prosecutor for an explanation. So the prosecutor typically advances a race-neutral explanation for the challenge, and then the judge determines whether or not that's genuine. But basically, this was put into place because there were a lot of cases where people were using these challenges to just, oh, it's a Black defendant, we'll get rid of all the Black people who could be on the jury because they'll be sympathetic. And that's not legal. In 1994, the Supreme Court extended the logic of Bastin to challenges based on gender as well. So this is JEB v. Alabama XRL TB in, again, 1994. So basically, these challenges, the peremptory challenges cannot be based solely on race or gender. If you're an attorney who's eliminating someone who is a minoritized gender or a minoritized race, you better have a good explanation. All right, so traditional jury selection is judged by the lawyer. And we're looking at things like stereotypes, beliefs, personality, attitudes of the people who make up the veneer. So what criteria each lawyer uses will depend on the incident and also the defendant. And there's a lot of suggestion from social science research that what happens here is an illusory correlation, where you believe things are linked with no evidence to back it up. So again, even something like, I'm going to get rid of all of the prospective jurors of the same race of the person because they're going to be sympathetic, isn't actually necessarily true. In some cases, members of that person's same race will actually judge them more harshly because they think they are misrepresenting the community. So basically, people use sort of false ideas to make these decisions. Trial lawyers often imply their own implicit personality theories to juror selection. And this is an implicit personality theory is a person's organized network of preconceptions about how certain attributes are related to one another and to behavior. And not surprisingly, these can be mistaken. They're not based on science. Attorneys also sometimes use strategies that rely on very different theories. So for example, the similarity leniency hypothesis is the assumption that jurors who are demographically or socially similar to a litigant will be predisposed to favor the litigant, as I just mentioned previously. But the competing one, which I also mentioned, is the black sheep effect. And the idea is that people may sometimes strongly sanction those fellow members who reflect negatively on and could embarrass the in-group. When the evidence against the defendant is weak or ambiguous, jurors tend to favor defendants who are like them in some way. So the similarity leniency hypothesis comes into play when there's not a lot of evidence. But when the defendant's culpability is clear, jurors are harsher on defendants with whom they share demographic features, which again, that's that black sheep effect. So these effects seem to apply only to individual jurors' demographic closeness to the defendant, not to the jury as a whole. Because we know from social psychology that when you get 12 people in a room, then all their personalities are going to interact and they'll influence each other and we'll get like in-group thinking and things along those lines. Some attorneys will just follow what's called the first 12 called rule. where the attorneys will always accept the first 12 people called up for questioning during voir dire. So sometimes they will deliberately draw jurors' attention to their willingness to believe that everyone is fair and can be trusted to decide the case correctly. Of course, then this in and of itself is a tactic, right? So to kind of get the jury on their side, like, I believe you, I don't need to question you, right? Things along those lines. In terms of demographic characteristics of jurors, trial attorneys must make informed guesses about which prospective jurors will be more favorable to their side. To do so, they often rely on those demographic features because they're more easily observable. However, juror demographic characteristics are only weakly related to juror voting decisions. And it also seems to drastically differ depending on the type of case. There has been a lot of research in this area and some sample findings here. In a study of attorney effectiveness, experienced trial attorneys were observed to use juror selection strategies that were no different from or better than those of inexperienced college and law students who were asked to evaluate mock juries. So very similar to what we talked about when we talked about profiling. Just because you have experience doesn't mean you can sort of judge someone off the bat. Attorneys don't actually predict any better than chance who will vote for their side. However, they do seem to be more accurate during murder trials. So how psychologists get involved is during scientific jury selection, also abbreviated SJS. And so it doesn't have to be a psychologist, it could be a criminologist, a sociologist, political scientist even, but they will help lawyers identify jurors that will help their cases. So here you'll have people who are much more attuned to human nature, who've often done research in this area, who might even have clinical training. And so they are a little more keen than sort of your average attorney. We see consultation in this capacity used much more often by the defense side than the prosecution in criminal cases. And so for the methodology, the social scientist consultant will actually do research essentially related to that particular case. So they might do a community survey where they measure the persuasiveness of arguments and evidence to be presented in a large scale survey. They'll also ask people about the perceptions of case characteristics, the litigants and trial related issues. They'll ask people their own backgrounds and activities, and they'll develop demographically based profiles of individuals who are most or least responsive to the themes in the cases. Then there's more specific pre-trial surveys where they'll give them to the individuals summoned to the courthouse for the trial. So they'll give them to the veneer who actually shows up. These cannot and won't include questions regarding evidence persuasiveness. They can also do essentially experimental trials where they do mock juries, where they examine how different types of individuals respond to different trial strategies and approaches to information presented. So for example, they might have the attorney give several variations on the opening or closing argument and see which is the most persuasive. Focus groups are similar to mock juries, but much less formal in structure, where you would just like present the argument and there'd be much more discussion about it. Many jury consultants provide services in realms other than jury selection as well. So for example, consultants can conduct public opinion surveys, focus groups, mock trials. They'll analyze how different jurors form a narrative that summarizes the evidence. And this allows consultants to derive central themes which can be used to organize the evidence to support the attorney's desired interpretation of the facts. So they'll, in addition to helping them select the jury members, they can help them essentially form a more persuasive argument. We need a lot more research in this area. It really depends on from the type of case, how accurate this is. So this actually works better in court-martial and drug cases. And the effectiveness of scientific jury selection can depend on a whole host of things, including how many peremptory challenges are allowed, right? So if you are only given one or two of those, right, it's not probably going to be that much use to hire a expensive consultant. The extent to which questions delve into matters beyond superficial demographic details of the prospective panel members, like are we doing that extended voir dire, then the consultant is going to be more helpful. Whether the attorneys actually act on the guidance of the consultant. You can consult all day and offer all kinds of good evidence, but if that attorney who's paying you ignores what you say, it's going to be less effective. And perhaps most importantly, their effectiveness relies on the extent to which jurors' attitudes and beliefs will actually determine the outcome of the case, right? If this is the case where there's like a mountain of evidence against the person, and probably any 12 people you pull up there would find this person guilty, it's not going to matter much, right? How you pick and choose those jurors. And so there's kind of two methodology that they look at here. Demographic characteristics. So is the panel representative of the community as a whole? But then they can also look at juror characteristics related to the outcome that the attorneys want. So they need to actually relate the characteristics to the outcome. They can ask the person how they would vote if they were on a jury in a community survey. The problem is if you give someone a community survey and they haven't seen all the evidence in the case, they might vote completely differently than once they have sat through the trial as a member of the jury, because they haven't heard all that evidence. So to fix it, you present the facts in an unbiased way during the phone survey or mock trial. Demographics tend to have a limited, weak relationship that may be case specific. They can be helpful in federal cases just because, again, there's this very short voir dire. There's not much else to go on. People who are richer, so higher socioeconomic status, are more likely to convict. We talked about, for example, the different ways race can go, the black sheep versus the leniency. One interesting thing is that African-American jurors seem more likely to support not guilty by reason of insanity. Gender in cases related to women and kids, women tend to rule in favor of the women, so they'll convict the rapist or child sexual abuser or sexual harasser more often. They also tend to acquit battered women who kill their husbands out of self-defense. And so, but things don't always go that way. I'll give you guys a quick example here. So, and this is actually going to be on the assignment that y'all will probably do on Tuesday. We had a case here several years back of a student who was sexually assaulted on campus. They did everything right under Title IX. And then the then dean of students, who is no longer here, wrote her a letter and basically said, we hope you can get over this. We've decided to let your rapist just withdraw so that he can enroll at another university and will mess up his future. I'm paraphrasing, but it was essentially that. So she sued the institution. Now, the unfortunate bit of this is that her attorney was basically an ambulance chaser. He had never done a sexual assault case. And apparently the university offered to settle with her several times, and her attorney just saying, no, no, no. So they got all the way to trial, and they actually had an all-women jury for the civil case, and they voted against Jane Doe because, again, her attorney did a horrible job. So it was really kind of sad because I think she could have gotten some sort of compensation for what happened to her, but her attorney led her horribly astray. So even those demographic characteristics don't always carry out. In terms of personality characteristics, authoritarianism, people high on this tend to convict and have harsher sentences. This is a personality trait where anyone who's perceived as having less authority than you is judged very harshly. But anyone who's perceived as having more authority than you is judged much more leniently. So these folks may want to please the judge and may even be influenced by nonverbals on the part of the judge. Another thing with personality characteristics they look at is locus of control. So if you personally have an internal locus of control, which means you think you are responsible for what happens to you no matter what, then you are more likely to believe that others are responsible for what happens to them no matter what, and thus more likely to convict. Alrighty, so again, we need more research on this, and this article isn't necessarily recent anymore, but there was a review article about scientific jury selection, and I called it Still Murky After 30 Years. Now we're at 40 years, and I would bet it's not much better. So whenever there's major litigation, attorneys will use trial consultants. We'll bring in social scientists like a psychologist to help them with voir dire and some of these arguments. But what's the effectiveness? Well, consultants themselves report high success rates. I mean, it's part of their advertising, of course they are. But part of what happens here is that it costs a lot to hire a consultant. So consultants are used in cases where premier attorneys are used, who are already going to have a better success rate on their own. They can also afford skilled expert witnesses. So it's unclear whether it's just having a consultant makes you more successful, or the overall just having more resources to pour into it is going to make you more successful. In terms of demographic factors, these tend to account for less than 2% of the variance in the verdict when examined independently. So if you look just at race, just at gender. Hello, helicopter. 2%. Gonna give that a second. There we go. If you examine all the demographic factors together, sort of look at it intersectionally, it's only accounting for about a 5% variance in the verdict. And so that's like how much that will influence their voting on the verdict. As I just mentioned, gender tends to be unreliable, but it's clearer in cases with sexual violence. There also tends to maybe be a legal personality or legal attitudes. And this would have a greater predictive accuracy if you use measures, specifically measuring these legal attitudes relevant to the trial at hand. So for example, one of the things this measure could ask is what's your attitudes toward psychologists or psychiatrists in a case where NGRI is a question. Even with all these factors, what we can predict remains fairly low because humans are complex creatures and are going to be influenced by arguments in ways that we can't predict. There's little research actually examining the effectiveness of SJS. Research out there suggests over 70% accuracy rates, but it's unclear how credible those are because they're often being done by the consultants themselves. And other times it's often highly artificial. Like if we're looking just at like mock jurors, right? That's an artificial setting. Or a lot of times it's not directly comparing when people use scientific jury selection to people who are using the traditional method. So it's hard to say. So it's suggested that SJS may be most beneficial when the evidence is equivocal. So the evidence is like unclear, can kind of go either way, and any slight advantage may impact the outcome of the case. Evidence strength, so how good the evidence is in a particular case is a much better prediction of the jury verdict than any of this stuff that you do in SJS. So again, remember, an individual juror characteristic is like 2% of the variance. All of them put together is like 5. evidence strength accounts for a third, 34% of the variance. So that's a big deal. So in cases where the evidence is really strong, SJS would be a really weak influence. But a lot of those cases don't even go to trial. There'll be a plea bargain. The defendant will be very clear that they're going to get convicted, right? And so try to plead down to get less time. Then again, if the evidence does seem relatively balanced, then there are small increases in predictability gained from SJS that could be helpful, advantageous. There are ethical issues here, obviously, as well. So critics of SJS have condemned these techniques as jury rigging, techniques that undermine public confidence in the jury system and give wealthy litigants an unfair advantage over poor or average income citizens. However, many believe that because litigants are expected to present their version of the case as zealously as possible, they should be able to use every legal means available to sway the jury and reach a favorable decision. Okay, right? It's an argument. All right, so sometimes there's a jury. In other cases, there's not. There's just a judge or a magistrate in the room. Defendants in criminal trials ordinarily have a jury trial, but if the prosecutor consents, they can choose to have a judge decide, and that's called a bench trial, as they call where the judge sits, the bench. Citizens believe a jury decision offers more procedural fairness, so greater thoroughness, better representation of the community, fewer personal biases affecting decisions than a decision made by a judge during a bench trial. So one of the questions that's come up in social psychological research and in criminology is, do judges and juries generally agree with each other? So Kelvin and Zeisel in 1966 looked at this. They asked judges questions about recent jury trials. They said, what was the jury's verdict and did the judge agree? In criminal and civil trials, judges reported that their verdict would have been the same as the jury's actual verdict in about 75% of cases, so 3/4 of the time. Only in 19.5% of the criminal cases did the jury return a guilty verdict, where the judge would have ruled not guilty, or vice versa. In most of the discrepant decisions, the jury was more lenient than the judge. So in terms of leniency, there is an advantage to jurors. Does that make them more fair? That's sort of a philosophical argument, right? So determinants of these discrepancies. A few of the discrepancies apparently resulted from facts that one party knew, but the other didn't. So for example, the judge might not have known all the facts that the jury got, or vice versa. In some trials, the jury was swayed by the apparent superiority of one lawyer. And about half the disagreements involved jury sentiments, feelings expressed by the judge that the jury verdict was determined by factors beyond the evidence and the law, so sympathy, things along those lines. There's also been a critique of this particular study. The judges were permitted to choose which trial they wanted to talk about in the study. And they also sent surveys to 3,500 judges, and only 555 returned them. So that's a very small percentage, right? So we're not representative of judges as a whole. Juries have also changed quite a bit since the 60s. Now we have some more civil rights. It's not perfect. We're fully acknowledging that. But so juries seem to be a little more representative. And we only have the judge's attribution of what the jurors' feelings and sentiments were. So we don't know for sure if that's really why they decided, or if some of the evidence was actually more persuasive for these particular jurors. Researchers at the National Center for State Courts collected data from jurors, judges, and also attorneys in more than 350 trials. And this study was published by Eisenberg et al. In 2005. And the rate of jury or judge agreement was 70%, so very similar to the Kelvin and Zeisel work. And when there's disagreement, again, the juries were more lenient than the judge. Jurors do tend to be more lenient than judges when it comes to determining guilt, but interestingly, they can be more harsh when it comes to sentencing decisions. So why? Why are they more harsh? One explanation is that jury trials are very expensive, and judges want to encourage defendants to plead guilty and avoid those costs. Thus, judges may deliberately choose more lenient sentences as an incentive to encourage plea bargaining. So a different study by the same research group in 2002 analyzed data from nearly 9,000 civil trials. And the primary finding from that study was that judges and juries do not differ substantially in these cases. They award punitive damages of about the same size. And although the range of jury awards was so much greater than that of judicial awards, they were still within the same ballpark. It wasn't like the juries would give millions and the judge would give thousands. All right, well, what about just the idea of trial judging in general? Well, yes, of course, psychologists have studied this too, right? That psychologists like to get into people's heads as much as we can to try to explain human behavior. So judgments are subject to influence by the judge's personality, by attitudes and past experiences, all manner of things. So what they found is that training and legal precedent really are important here. So lawyers are taught to look at facts and to reason by analogy. This is actually part of the LSAT, right? Is that you do these like logic puzzles. So they're going to apply facts and place things in categories. And this can be really similar to a scientific disciplines approach. And the vast majority of judges were originally lawyers. Judges are typically lawyers who get elevated from that position. However, legal decision-making also has heavy deference to precedent. You have to kind of go with previous case law. If you stray too far, the case will be appealed and it's possible your ruling will be overturned. So you're sort of limited by that reason as well. And the judges are dependent on the evidence presented. And this can really affect the quality of your decision. If there's an important piece of information out there, but the defendant's attorney didn't have the resources to get it, and the prosecutor knew it was against their favor, so they didn't present it, right? You're missing important pieces. And so as we mentioned way at the beginning of the semester, in some European countries, the judge has investigative powers, and that gives them more of the ability to actually have some control over the information. Legal training does not seem to insulate judges from common cognitive errors. So in one study, judges were presented with inadmissible evidence and told they should disregard this evidence. And despite their legal training, judges were similar to laypersons in that they could not disregard. It's sort of like once you hear something, it's in your mind, and you might even forget you were told to disregard it. And others show that judges are as prone to stereotypes as anyone else. Again, not surprisingly, they're human beings, right? Sentencing decisions, there are disparities based on race, ethnicity, and gender. We see longer sentences, for Hispanics and African Americans. Some suggest that this may be influenced by courtroom behaviors, but it's also obviously largely influenced by pre-existing prejudices. Also, there's a disparity in things like probation officers or legal representation based on race, which is also problematic. Alrighty, so what I'm going to do is actually just go ahead and start the next lecture. And then next week, we'll go ahead and do the 2 assignments and watch the movie. But this will give us some nice background to set us up for all of that. So we're going to start talking. Okay, so we've got the jury, right? They've been selected. And they've heard all the evidence and now they're gonna deliberate. So most legal disputes are resolved without a jury trial, but there's still more than 150,000 jury trials conducted within the US each year. Approximately 2/3 of Americans have been called to jury duty, and approximately 1/4 have actually served as jurors. Juries have been criticized. So some people think that there's like excessive awards from civil trials, even though, again, the previous studies showed that like judges and juries don't actually decide that differently. But juries also have their defenders. So verdicts reached by representative juries can and often do increase the legitimacy of the process in the eyes of the public, particularly during controversial trials. One of the questions that has brought up over and over, though, is we've got a bunch of sort of Joe and Jane schmoes, right, that we bring in, and then we ask them to make these really important legal decisions. Are they competent to do that? They have no legal training. And so psychologists have examined factors that affect the accuracy of jury verdicts. We've learned that, as we talked about the last PowerPoint, evidentiary strength is probably the most important determinant of jurors' verdicts in both civil and criminal trials. As well it should be, right? If the evidence is clearly against you, that should be a huge determinant. But jury decisions, not surprisingly, can also be influenced by extra legal information. So that's irrelevant information about the defendant's background or even their appearance. So why are jury decisions influenced by this irrelevant information? Well, the same Kelvin and Zeisel study we just talked about, they came up with something they called the liberation hypothesis. So when the evidence in a case clearly favors one side, juries will decide in favor of that side. But when the evidence is ambiguous, jurors are liberated from that sort of hold and allowed to rely on their assumptions, sentiments, and biases, that extra legal evidence, in reaching a verdict. So the mechanism by which juries reach these decisions is called the dual process theory of attitude change, and this comes from researchers Eagley and Shaken in 1993. And this distinguishes two different kinds of information processing strategies, or like routes to making these decisions. Central is where you'll focus on the evidence, but when the evidence is confusing, then jurors will switch to peripheral, which is focusing on those extraneous details. Once jurors have heard evidence about a defendant's prior criminal record, they may be prejudiced by it and judge the current offense in light of the past misdeed. So the prosecution is often not permitted to introduce this evidence. But if defendants take the witness stand, then prosecutors may be able to question them about certain types of past convictions in which to impeach their credibility as witnesses. Remember, even if they say it and the opposing attorney objects and it's sustained, the jury's already heard it, right? And so they're already going to be influenced by it. If the defendant takes the witness stand, the judge may issue, to kind of account for this, what's called a limiting instruction, which is that evidence of a defendant's prior record can be used to gauge the defendant's credibility, but not to prove the defendant's propensity to commit the crime, the charged offense. Not surprisingly, given everything we've talked about the human brain and how it's hard to unlearn something, limiting instructions are rarely effective. Thus, attorneys are often recommend that clients with prior records not take the witness stand to testify on their own behalf, sort of protect against this. In studies, mock jurors who are informed of the defendant's prior conviction were much more likely than jurors who had no such information about a prior record to convict the defendant on subsequent charges, although similarity of the charges was found to be an important variable. So like if this person is on trial for murder and they previously like stole something as a kid, probably not going to influence it that much. Most courts permit a criminal defendant to be tried for 2 or more charges at the same time, as long as the offenses are similar or connected to the same act. This process is called a joinder. And so in fact, this big trial you may have heard of going on in New York, right? This guy named Trump, he has 34 charges, right? And those are all being considered at the same time. Researchers have found that defendants are more likely to be convicted of any single charge when it's tried in combination with other charges than when tried alone. So if you're already saying they're guilty of one thing, you may be more likely to say they're also guilty of other things. Historically, evidence about a defendant's character and propensity evidence or evidence of other wrongdoing could not be used in court. Sex crimes, however, are treated differently in federal court and in some states. Evidence of other sex offenses is admissible to show a defendant's propensity to commit the charged sex offense. So what might propensity evidence have on jurors? Jurors are much more likely to make the fundamental attribution error in these cases, where they'll say, well, this person is just a horrible person, and so let's lock them up forever. And that may be accurate, right? But we know it's being influenced by the presentation of this other material. Kind of similar to this in these cases, sad that like we had to do this, but there actually had to be rules and laws and regulations that say like the victim of a sexual offense of their sex history can't be brought up, because people would then judge the victim based on that. So in civil cases, juries are going to typically make 2 fundamental decisions. So whether the defendant, or sometimes in some instances, the plaintiff, is liable. Liable means they're responsible for the alleged harm. So again, I just keep using this case because it's so recent, but this is a good example from the Gwyneth Paltrow case, where this guy said, Gwyneth ran into me, and she said, no, actually, you ran into me. And it turned out that that was actually, she was telling the truth. And so the guy who was the plaintiff was actually held liable. No, Gwyneth was just trying to make sort of like a legal and ethical point. So she only asked for $1. And she was like, I got enough money. I don't need to get your money. The other decision that juries in these civil cases are making is whether the injured party, typically the plaintiff, should receive any money to compensate for their losses or injuries, and if so, in what amount. These monies are called damages. So when psychologists study juries' liability judgments, what the psychologists are asking is how people assign responsibility for an injury. So jurors should decide liability on the basis of the defendant's conduct. The severity of an injury or accident should be irrelevant to a judgment concerning liability or legal responsibility. Do jurors ignore that and determine liability correctly? Right. So why would we assign more responsibility to an individual as the consequences of their conduct became more serious? One explanation is the defensive attribution. So as the consequences of one's actions become more severe, we're more likely to blame a person for their occurrence, because doing that makes the incident somehow more controllable and avoidable. So if we say like, I wouldn't do what this person did, then you feel safer. Now, in terms of assessing damages in state civil courts in 2005, the median damage award was $28,000, which is still a nice chunk of change, right? But only 4% of plaintiffs received more than $1 million. And so I think we often hear about the lawsuits where people get multiple $1 million awarded to them, right? And so we tend to think that's all lawsuits, but in a lot of cases, you're actually just sort of like trying to get the money from your insurance or something along those lines. In general, the more a plaintiff requests, the more that plaintiff receives. These are those anchor points we talked about before. So jurors tend to adjust their awards towards those anchor points. The most obvious of which is the plaintiff's requested damages. So you might ask for $10 million in the hopes that you might get like $5 million. Instead of if you asked for, $1 million, you might get $500,000. What factors do jurors consider in their decisions about damages? As in criminal cases, jurors put the most weight on the evidence they hear in court, as they should. But sometimes they consider attorneys' fees and whether any loss is covered by insurance, issues that are theoretically irrelevant to the decision about the amount of damages to award. Just like with criminal cases, most of the evidence indicates that a judge's admonition to disregard inadmissible evidence is relatively ineffective. Jurors are more likely to comply with the judge's instruction or to ignore inadmissible evidence if the judge provides a reason why it's inadmissible. Instructions to ignore inadmissible evidence can backfire and actually result in the jurors being more likely to use it because they remember it more because it was sort of highlighted or pointed out. Jury deliberations can lessen this impact because other people in the room can be like, oh, hey, remember the judge told us to not consider that. Okay, so we know that psychologists and other experts can testify, and that these cases, in theory, the reason you're asking these expensive experts to come in is to help sway the jury. So experts typically testify about scientific, technical, or other specialized knowledge with which most jurors are not familiar. Because jurors lack rigorous and analytical skills, they may use what's called the peripheral processing, paying attention to those superficial aspects of the expert's testimony. And obviously, that's not supported by evidence. Expert testimony will sort of mesmerize jurors at times, causing them to discount their own common sense and rely too heavily on the opinions of these experts. Evidence does suggest that when prosecutors introduce expert testimony, convictions are more likely. When experts testify on behalf of the defense, the likelihood of conviction decreases. Now, obviously, if both sides is bringing in expert witnesses, that might just kind of balance out, right? Research suggests that jurors do not routinely defer to the expert's assessments necessarily. Judges who ultimately decide what expert evidence is admitted, so this goes back to that Dauber case we talked a lot about in our first lecture. Judges are fallible, and they can sometimes allow unreliable expert testimonies to be admitted into evidence. Are jurors able to distinguish between reliable scientific evidence and junk science? No, because normal people can't, right? And in fact, even some very smart people with PhDs can't, to be perfectly honest. So they're unable to distinguish valid from flawed research. All right, now, so when the judge gives the jurors instructions, do they have the ability, the capacity to understand those and implement them? Well, the greatest weakness for many juries is their inability to understand their instructions. These instructions are often full of legalese, legal terms that are unfamiliar to lay people, and jurors may or may not be provided with a written copy of the instructions. It's so like they're only hearing it, and people are not always good at remembering everything they hear correctly. And in most cases, and in fact, almost all cases, they are not allowed to ask questions in the courtroom to clarify misunderstandings they may have about their instructions or about the law. Psychologists who study, sort of the effects on jurors have been able to simplify jury instructions that have been shown to be easier to understand by jurors, and therefore they pay more attention to them. Although those in the legal system have not generally been receptive to reforms suggested by social scientists, some have actually revised portions of their jury instructions. So, for example, the state of California used these suggestions by social scientists. Although instructions are typically read just before the jury retires to deliberate, some states now require judges to provide preliminary instruction before the evidence is presented so that the jury sort of understands the process. Instructing the jury at the conclusion of trial reflects a belief in the recency effect, that recent events are generally remembered better than remote ones. The idea that juries should be instructed before the presentation of testimony because it gives them a mental framework to appreciate the relevance or irrelevance of the testimony as it unfolds rests on the notion of the primacy effect, that instructions will have their most beneficial effect when presented first. Fosterly and Horowitz in 2003 reported that mock jurors who received instructions at the beginning of the trial recalled and used more of the evidence than did jurors who were instructed after the evidence. So perhaps some evidence in favor of that. Jurors who received pretrial instructions said that they were able to focus better during the trial because they understood sort of what they were looking for. Judges also believe that substantive preliminary instructions help jurors to follow the evidence as it goes through. Juries have the power to acquit defendants despite evidence and judicial instructions to the contrary, although they often don't know they have this power. And this power turned jury nullification has permitted juries to acquit defendants who were legally guilty but morally upright. So how would juries behave if they were informed they had the option to essentially kind of disregard the law? Data from, again, Horowitz's research group in 2006 showed that jurors tend to rely on their feelings and sentiments to nullify the law only when that law seems unfair. Or if, again, like, this is an upstanding member of the community or a celebrity or something along those lines. Complex cases often require the jury to render decisions on causation, liability, and damages for multiple plaintiffs, multiple defendants, or both. In criminal cases, the use of forensic evidence can also contribute to case complexity. So DNA, things along those lines. Many arguments have been made against the use of juries in complex cases. So the evidence maybe being too difficult for a layperson to understand. The general information load on juries is excessive because of the large number of witnesses. And that less capable jurors are left to decide due to voir dire, getting rid of the social scientists, getting rid of the lawyers, right, who might be part of the veneer. The complexity of the trial does impact jurors. So again, from Horowitz's research group, they found that complex language lessened jurors' ability to compensate plaintiffs who were suffering injuries of varying severity. Overall, findings point to the need for attention to how complex a case is presented to the jury. So, for example, some places now allow jury members to take notes. Okay, so the big question, are juries biased, just sort of overall? So courts assume that jurors can put aside any preconceptions about defending guilt or the merits of civil defendants and plaintiffs when forming judgments. Is a fair and unbiased jury an impossible ideal? Well, attorneys are motivated to select jurors who are favorable to their own side, and it's impossible for anyone to be completely uninfluenced by past experiences and resulting prejudices. So juror bias is a single juror's predisposition to interpret and understand information based on past experience. Personal predispositions may affect views toward the prosecution and or the defense and affect the way that the evidence is evaluated. Jurors may also show what's called pre-decisional distortion, distorting the evaluation of the evidence to support their verdict choice. So do jurors' biases predispose them to favor one side over another in a civil case? Although elements of sympathy do play some role in deliberations, as do feelings of anger towards either party, the general public has been found to be quite suspicious of and sometimes downright hostile to civil plaintiffs. There's this idea that, like, oh, you're just trying to get money, we live in this litigious society, and blah, blah, blah. Do juries give larger awards when a defendant is wealthy? jury damage awards are consistently higher in products liability and medical malpractice cases than in things like automobile negligence cases. It appears that any inflation of awards against corporate defendants is apparently related to their status as a corporation and not to their wealth. So corporations are held to higher standards of responsibility than are individuals. So how do jurors make sense of the evidence they hear during the trial? So jurors construct stories about the evidence as it makes sense to them. In the process, they pay attention to certain pieces of evidence while ignoring other pieces of evidence. Hesty and Pennington developed the story model to describe inferences that individual jurors make when reaching a decision in a case. Cool, so we're going to talk about jury reform on Tuesday, and then we'll do the first assignment, then we'll start watching the film, we'll finish that on Thursday and do the second assignment. So everybody have a great weekend, enjoy the weather while it lasts. Apparently it's supposed to rain and get yucky again. And take care of yourselves.